Hey there, welcome back to the Deep Dive. So, you're interested in California real estate. It's quite the market, right?
Oh, absolutely. It's vibrant, competitive, and, well, legally complex.
Exactly. More than just nice houses and bidding wars. There's this whole layer of state-specific law.
And understanding that layer, it's not just helpful, it's essential if you want to succeed and, operate ethically.
It really is the difference maker, turning you from just an agent into, like, that trusted advisor people really need.
That's a great way to put it, because California's rules, they're robust. Lots of focus on protecting the consumer.
Which brings us to the California Department of Real Estate, the DRE.
Mm-hmm. The DRE. Think of them as the rule book and the referee for pretty much all things real estate in the state.
The rule book and the referee. I like that. So what's their main goal then?
Well, their official mission, and this is key, is maximum protection for persons dealing with real estate licensees and for purchasers of subdivided real property.
Maximum protection. That's pretty clear. It sets the tone.
It really does. It tells you exactly where their priorities lie. Consumer safety, first and foremost.
Okay, so maximum protection. How do they, actually do that? What are their main jobs?
Well, it really starts with who gets to be in the business. They qualify applicants, they issue the licenses.
Right, for brokers.
Salespersons. Yep, brokers, salespersons, and even some specialized folks like prepaid rental listing services and mortgage loan originators. They're basically the gatekeepers.
Gatekeepers. Okay, so they let you in, but then what? Are they still involved?
Oh, yeah, definitely. They don't just hand out a license and walk away. They enforce the rules. They investigate complaints
Against licensees.
against licensees, sure, but also against people operating without a license, which is crucial.
Hmm.
And a big piece of their oversight is regulating subdivision sales and leases.
Ah, subdivisions. That's a huge topic in California history and development. We should probably circle back to that one.
We definitely should. It's a major area. They also regulate dealings in mineral, oil, and gas properties and those prepaid rental listing services, too.
So, a pretty wide net.
It is. And importantly, they also provide resources. Things like the real estate law book, the reference book, pamphlets like instructions to license applicants. These are really the essential guides.
Having those official resources must be vital. Okay, so let's clarify the terms. We hear licensee, broker, salesperson. What's the difference?
Good question. So, a real estate licensee basically is anyone holding a license under the law, either a broker or a salesperson.
Okay.
A real estate broker is licensed to operate their own business, supervise others, be independent. A real estate salesperson holds a license but must be employed by a broker to do licensed activities.
They need that broker oversight. Got it.
Yeah.
And what are those licensed activities? Just buying and selling homes.
That's a big part of it, of course, residential, commercial properties, but it's broader. It includes things like selling mobile homes, believe it or not.
Really? Mobile homes too.
Yep, under certain circumstances. And a huge area is real estate finance, mortgage loan brokering, loan origination, especially with the SAFE Act rules. Also, handling trust deeds, real property sales contracts, especially with multiple investors.
Wow, so it really follows the type of property and the money involved, even into areas like finance that might seem separate.
Exactly. And things like advance fee brokerage, dealing with mineral rights. It's all under their umbrella if it involves real estate transactions for others.
Okay, so how does someone actually get into this, get licensed?
Well, the basic path involves meeting certain education and sometimes experience requirements, then applying to the DRE, paying a fee, and passing a pretty tough exam.
For a salesperson license, you take the exam first.
Usually, yeah.
Mhm.
Apply for the exam. They have an online system now, a licensing, which helps. Pass the exam, then apply for the actual license.
And for a broker license,
Hmm.
that usually requires experience, doesn't it?
Typically, yes. The standard is 2 years of full-time salesperson experience within the last 5 years. And your broker needs to verify that using specific DRE forms like the RE-226 or RE-228.
2 years full time. Is there any other way?
There is an alternative. A 4-year college degree from an accredited school with the required real estate courses can often substitute for the 2 years of experience.
Ah, so education can be a route too. That's good to know. What if a company wants to be a breaker?
A corporation can get a broker license, but they have to designate a specific licensed individual broker as their responsible broker officer. That person is responsible for the company's licensed activities, and they need to file corporate paperwork with the DRE.
Okay. And you mentioned an MLO endorsement earlier, mortgage loan originator. How does that work?
Right. If you're going to be involved in originating mortgage loans, you need that separate endorsement on your license. It's handled through the NMLS, the nationwide multi-state licensing system.
Another layer of approval.
Yeah, it involves passing a national test, the SAFE test, submitting a detailed application, fingerprints, credit check authorization, and completing 20 hours of NMLS-approved pre-license education.
So specific training for that specific function. Makes sense. Now, once you have the licensed salesperson or broker, you can't just coast, right? There are ongoing requirements.
Absolutely not. Both the real estate license and the MLO endorsement require continuing education, or CE.
How often?
For the MLO endorsement, it's 8 hours every year, and the courses have to be NMLS approved. That's separate from your real estate CE. For the real estate license, you need to complete specific CE courses before you can renew your license, typically every 4 years.
And what if you miss the deadline? Life happens.
You have a grace period, sort of. You can renew late, but only within 2 years of the license expiring. You have to file the right forms, pay a higher late fee, and complete the required CE.
But you can't work during that time.
Critically, no. You absolutely cannot conduct any licensed activity while your license is expired. That's a serious violation.
Okay, that's a really important point. Don't work on an expired license. Let's shift back to the broker's role. You mentioned the responsible broker. What does that really mean?
The responsible broker is the designated broker who has the duty to supervise the salespersons working under them. It's a key part of the DRE's oversight structure.
Supervising. Like telling them how to sell.
Not necessarily sales strategy. The supervision required by the DRE is focused on ensuring the agents comply with the real estate law and regulations, basically, protecting the public.
Regulatory compliance and consumer protection.
Yeah.
Okay. What about brokers using a different business name, a DBA?
That's common. Operating under a fictitious business name, or DBA. If you do that, the DRE license itself must show that DBA name. And you also have to file the fictitious business name statement with the county clerk.
And advertising with that DBA.
Rules there, too. Any advertising using the DBA must also clearly and prominently display the responsible broker's identity. It can't be hidden. Again, it's about transparency for the consumer.
Transparency seems to be a recurring theme here.
It really is fundamental to the regulations.
Now let's talk about something super critical. Handling other people's money. Trust funds. This feels like a major area for potential trouble.
It absolutely is, and the rules are strict for good reason. Any funds a broker accepts on behalf of someone else, like that earnest money deposit from a buyer, must go into a designated trust fund account.
It's a totally separate account.
Total separate. It cannot be commingled, meaning mixed, with the broker's own business or personal funds. Must be kept apart.
What if the trust account earns interest?
If it's set up as an interest-bearing account, there have to be clear written disclosures to everyone involved about who gets the interest, who pays any MANC fees, withdrawal limitations, all of that.
Okay. And who can actually take money out of that trust account?
Only specific people,
Yeah.
usually the broker who's the signatory or the designated broker officer for a corporation. A salesperson or even an unlicensed employee can be authorized, but only if they are covered by a fidelity bond sufficient to cover the maximum amount they might handle.
So, tight controls on withdrawals. Are there any circumstances where a little bit of the broker's own money can be in that account without it being considered commingling?
Yes, but they are very, very specific and limited exceptions outlined in Regulation 2835. A broker can keep up to $200 of their own money in the trust account, but only to cover bank service charges or fees.
Just $200 for fees. Okay.
And if the broker has earned a commission or fee that's currently in the trust account, they can leave it there for no more than 25 days before they have to withdraw it.
25 days max for earned income. That's incredibly precise. They really want that separation.
They absolutely do. And to track all this, brokers are required to do a monthly reconciliation. They have to match the bank statement for the trust account against their separate records for each client or transaction.
That sounds like a lot of careful bookkeeping.
It is, but it's a critical control. It helps catch mistakes or, potential misuse of funds early.
Understood. Okay, let's move from general conduct to some specific laws protecting consumers. What about the subdivided lands law you mentioned earlier?
Right. This is a big one in California, designed to prevent fraud and misrepresentation when developers sell lots or units in subdivisions. The core requirement is that the developer must get a public report from the DRE before they can sell or lease those interests.
A public report. What does that tell a potential buyer?
It's a disclosure document. It gives buyers important information about the property, like the state of the title, how financing works, availability of utilities, any common areas, homeowner assessments, restrictions. Basically, the key facts they need to make an informed decision.
So you get the facts before you buy. Are there different kinds of these reports?
Yeah, there can be conditional reports, for instance, which allow some early marketing but have time limits, usually 6 months, maybe renewable once. And there are fees associated with filing for these reports, of course.
And does the DRE watch how these subdivisions are advertised too?
Yes. The regulations prohibit advertising that implies a use for the property that isn't actually permitted or described in the application for the public report. Keeps the marketing aligned with reality.
Makes sense. Okay, another specific area. Timeshares. California has rules for those too.
It does, the Timeshare Act. It applies to timeshare plans that either have property located in California or are sold to people in California, even if the property is elsewhere.
And what's unique about how California treats them?
Well, one key thing is that a timeshare estate is legally considered a separate interest in real property, like owning a fraction of the actual real estate for that time period.
Interesting. What protections are built in for buyers?
Developers have a duty to supervise the offering. They have to provide detailed disclosures, especially about any exchange programs and their fees. And importantly, they need to provide financial assurances like a surety bond or a cash deposit to guarantee they can cover assessments on any units they haven't sold yet.
So the existing owners aren't left holding the bag if the developer still owns units.
Exactly. It protects the solvency of the homeowners association.
Okay, let's shift gears a bit to the relationship itself. Agent and client. Agency and fiduciary duty. This feels fundamental.
It absolutely is. It's the cornerstone of the licensee-client relationship. When you agree to act for a principal, buyer, seller, lender, whoever you create an agency relationship.
And that comes with a special duty.
Yes, the fiduciary duty. It's the highest duty recognized by law. Courts often compare it to the duty a trustee owes to a beneficiary. Utmost care, integrity, honesty, and loyalty.
Utmost care, integrity, honesty, loyalty. That's a high bar.
It is. It means your principal's interests must come before your own. No self-dealing, no secret profits. This applies whether your authority is explicitly spelled out in an agreement or just implied as necessary to do the job.
What about representing both sides? Buyer and seller. Dual agency.
Dual agency. It's allowed in California, but it's tricky. You absolutely must have the informed written consent of both parties. If you don't disclose it properly and get that consent, it's a serious violation. The deal could even be undone.
Wow. So full transparency and written consent are non-negotiable there. What if an agent acts without authority or doesn't say who they're working for?
Big potential problems. An agent can actually become personally liable on a contract if they exceed their authority or don't clearly identify their principal on the agreement. Always make sure the principal is clearly named. And remember, for an agent to enforce collection of a commission, the agreement spelling that out generally needs to be in writing.
Good point. Write it down. Okay, let's circle back to finance. You mentioned mortgage loan brokers or MLOs. Are there specific rules for them beyond the licensing?
Yes, several consumer protection rules apply. For instance, there are limits on how much can be charged for a late payment on certain loans. Typically, it's capped at 10% of the installment with a $5 minimum.
Okay.
There are also significant restrictions on balloon payments, those large lump sums due at the end of a loan term. These are often prohibited or restricted on smaller loans or loans secured by owner-occupied homes.
To prevent people getting caught out by a huge payment they can't make. You also mentioned higher cost or higher priced mortgage loans. What defines those?
These are loans where the annual percentage rate, the APR, is significantly higher than the average market rate at the time, like 1.5 percentage points higher for a first mortgage or 3.5 points for a second mortgage.
And if a loan falls into that category?
It triggers extra protections and restrictions, things like strict limits or outright bans on prepayment penalties, preventing negative amortization, requiring ability to repay analysis, and often restricting balloon payments, too. It's really aimed at curbing predatory lending terms.
Got it. What about brokers who work with private investors? Arranging loans funded by individuals rather than banks. Private money, they call it.
Right, that adds another layer. When a broker arranges loans funded by private individuals, they aren't just dealing with real estate law, they're often dealing with securities law, too, specifically California's corporate securities law.
Securities law? Why?
Because that promissory note secured by real estate, when sold to an investor, can be considered a security. So the broker needs to provide specific disclosures to these investors, almost like an offering document detailing the risks involved. Sections 102.3d2.4 and 102.3d7 of the law cover a lot of this.
Complex. And then there are federal laws too, right? Like truth in lending?
Absolutely. The Truth in Lending Act, or TILA, implemented by Regulation Z, is huge. It applies to most consumer credit, especially loans secured by a dwelling. It requires clear disclosure of loan costs and terms, like the APR and finance charge. It regulates advertising, too.
And doesn't TILA give borrowers a way to back out sometimes?
Yes, the right of rescission. For certain types of loans, like refinances or home equity loans on a primary residence, the borrower gets a 3-business-day cooling-off period after closing.
3 business days to change their mind.
Exactly. They have until midnight of the 3rd business day after they sign the loan docs and receive the required TILA disclosures and receive the notice explaining their right to rescind. If any of those are missing or incorrect, that rescission period can actually extend much longer.
Wow. Okay. Business day includes Saturday, right? Just not Sundays or federal holidays.
Correct. That's important to calculate correctly.
What about escrow accounts for taxes and insurance or affiliated businesses?
Yep. Federal rules under RESPA, the Real Estate Settlement Procedures Act, regulate those escrow or impound accounts. And RESPA also requires an affiliated business arrangement, or ABA, disclosure if you refer a client to a settlement service provider like a title company or escrow company that your brokerage has an ownership interest in. Transparency again.
Always back to transparency. It feels like California law, layered with federal law, creates this really intricate web. Are there other big protective laws we should touch on?
Definitely. Fair housing is critical. The Federal Fair Housing Act prohibits discrimination based on race, color, religion, sex, disability, familial status, or national origin. California law often adds more protected categories. There are also specific state laws about senior housing communities.
It's important stuff.
And understanding basic property ownership concepts in California is vital, like community property rules for married couples, and things like declared homesteads that can protect some home equity from creditors. Even basic contract law ensuring there's genuine assent, free from fraud, mistake, duress, or undue influence is fundamental protection.
Woo. Okay, this has been a really comprehensive look. It's clear that navigating California real estate law isn't simple.
Not simple, no. But understanding these layers, the DRE's role, the licensing, the rules on trust funds, subdivisions, timeshares, agency duties, finance regs, fair housing, it's not just about avoiding trouble. It's the foundation of expertise.
It really elevates you, doesn't it? From just facilitating a deal to being that advisor who truly understands the landscape and can protect their client's interests within it.
Precisely. That's how you build trust and uphold the integrity of the whole profession. Mastering these details is delivering that maximum protection the DRE talks about.
So for you listening, try to see this complexity not just as rules to follow, but as the knowledge that empowers you, is what makes you a true California real estate professional.
Absolutely. And here's something to think about. So many of these core principles, fiduciary duty, disclosure, protections in subdivision sales, they were established long before our current digital age. How do you think these fundamental ideas of consumer protection need to adapt, or how are they already adapting, to things like online transactions, iBuyers, or even AI playing a role in real estate?
That's a great question for the future. How do these foundational rules apply in a rapidly changing world? Definitely something to chew on. Thanks for joining us for this deep dive. We'll catch you next time.